welcome back to my YouTube channel. If you're new, my name is Natlachang and I talk everything love and law. Today I am going to be talking about marriage regimes in South Africa. But before I go any further, please like my video, please subscribe if you haven't, and please share with your homies. So in South Africa, there are two major marriage regimes, and that is in community of property and out of community of property. Out of community of property can be divided into with accrual or without accrual, and I'll talk about that shortly. So in community of property, when you get married in community of property, it means that you come in with your estate, your spouse comes in with their estate, and both your estate form a joint estate. Upon death or divorce, your joint estate gets divided into equal shares amongst both of you. Also, it means that your debts and liabilities are shared. It means that if one spouse is declared insolvent, then the joint estate is insolvent. It means that creditors can also, your spouse's creditors can also come and claim their money from you as well. But also it means that you guys get to share each other's assets. But it's obviously a disadvantage for a person who has a lot of assets. But I mean, marriage shouldn't be about, oh, I have this, you don't have anything. That's just off the record. My advice is that don't get married in community of property. It's not spiritual, it's not biblical, nothing like of the sorts, you know. It's just wisdom. Don't do it, okay? Don't do it. So out of community of property, without accrual means what's mine is mine before marriage, what's mine is mine in marriage, and what's mine is mine when we leave the marriage, if the marriage ends. So the estates never join at any point. My creditors are my creditors, my liabilities are my liabilities, my assets are my assets. I do not have to worry about my spouse's creditors coming after me if he has creditors or if he's got liabilities, because our estates are separate. In order for you to enter into a marriage out of community of property, whether with accrual or without accrual, you need to enter or sign an anti-nuptial contract. Now, an anti-nuptial contract can be drafted and executed by a notary, and a notary is an attorney with an additional qualification. So you would meet up with your notary and discuss the terms of your anti-nuptial contract. You will either include the accrual system or you exclude the accrual system. And then once you've signed it, your notary will register the anti-nuptial contract with the deeds office, and that must be within 3 months of the signature. Now, anti-nuptial contract with accrual. So I'm going to give an example because I don't know how to explain it without the example. So my estate at the beginning of the marriage would be calculated. The net value of my estate would be calculated at the beginning of the marriage. The net value of my estate, should there be a divorce, will be calculated when the divorce happens. The net value of my spouse will also be calculated at the beginning of the marriage, and the final value at divorce will also be calculated. The difference in my estate and the difference in his estate must be set off. So if at the beginning of the marriage I have my net value is 200,000, and at the end of the marriage my net value, my final value is 1 million. Then the increase in my estate was 800,000 during the marriage. If my spouse's estate at the beginning of the marriage was 500,000 and at the end of the marriage it's 1 million, then his net increase was 500,000. Now, because my estate increased by 800,000, it means and he's increased by 500,000, it means my estate increased more than his. So the difference between his increase and my increase must be divided. So you would say 800,000, my increase, minus 500,000, his increase, gives you 300,000. Then you divide that by 2, then you get 150,000, and then I would get 150,000 and my spouse would get 150,000. Essentially, it brings both estates to the same amount. The nice thing about accrual system is that you can choose to exclude certain assets from your antinuptial contract, and you can choose to include certain assets from your antinuptial contract. Importantly, an inheritance that you receive or donation that's made to a particular spouse is not included when calculating the estate value of that particular spouse in accrual systems. So that means that remains your property or your asset, and it never forms part of the accrual system. Now, customary marriages. Customary marriages are automatically in community of property if you do not sign an antinuptial contract. So they are just like civil marriages. If you do not enter into an antinuptial contract, then your marriage is in community of property. So if you want to avoid being married in community of property and you are going to be married customarily, then you need to enter into an antinuptial contract. So the law does prescribe that customary marriages must be registered with the Department of Home Affairs within 3 months of the marriage. And that's just so that you can prove that the marriage exists. Because I can imagine that if you don't register your customary marriage and ish hits the fan, then it might be a little bit difficult, not impossible, to prove that, the parties were married. And lobola is not a requirement, by the way, for a customary marriage. So in order to enter into a valid customary marriage, you must be over the age of 18, both parties must consent, and then the marriage must be entered into and celebrated according to the customs of customary law. I hope I phrased that properly. And failure to register a customary marriage with the Department of Home Affairs does not invalidate a marriage. Yeah, speak to your lawyers, speak to your spouses, and agree and do the things. But don't let the law decide for you because you didn't plan.